Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and we're going to continue our video series designed to educate the public. So please subscribe to our channel. Today we're going to talk about the issue of whether or not courts allow a 50-50 long-distance co-parenting arrangement with kids. Now, you have to understand that a lot of times the 50-50 long-distance relationship occurs before the courts get involved in it. You know, you got a married couple, for example, somebody's taking a job out of state, they thought they'd be able to do it locally, turns out they're spending a lot of time in New Orleans because they have to set up a network or something like that. Meanwhile, the other spouse is home with the kids, and you know, this is how they're living. And they're living like this, and now things fall apart and they're getting divorced, and the question is, can they somehow maintain this 50-50, and does the court order that? Well, you got two competing factors here. Factor number one is that the court is a big fan of maintaining the status quo. So when the court has to make a decision about what should happen, the instinct of the court is to look and say, well, what's already happening? What is working already? Because the court is a lot about, if it ain't broke, don't fix it, so long as it's legal. So you've got that aspect of it. On the one hand, the court, is a fan of maintaining the status quo. On the other hand, the status quo has to make sense. And maybe in the context of a marriage that's working, the status quo makes sense on a temporary basis. But then if we're going to look at it and we're going to say, well, gee, this is what we want to put in place permanently in a divorce scenario, the court might not think that that makes so much sense. Can you maintain these strong relationships between child and parent in the long distance scenario? If you can, great. If the court gets a sense that it's working, I do think the court will exalt its first primary directive of maintaining the status quo and let it continue to work. But if it's not, you might well expect that will be a change, and there will be legal considerations associated with such long distance relationship, because it becomes a question of, well, how do we work it out? I mean, normally, let's say Father's Day is with Dad, Mother's Day is with Mom. Can we work that out in the long distance scenario? Can the parameters that the court orders be maintained? And if they cannot, then we have all sorts of legal considerations about whether or not we're violating the court orders. I would say this, in terms of strategies for making it work, the first thing the parties have to do is they have to chisel out, reconstruct a calendar on what definitely works. Things that long distance parties can certainly agree on, that they should nail down and put to the side. They should focus energy on the gray areas, on the things that might work if we tweak them, and try to focus on those. And the third section, the section where we absolutely will not agree, well, then you might have to go to the court and let the court, through its own devices or perhaps through the assistance of mediators, work that out. But that, I think, is the approach when we're talking about 50-50 long-distance relationships and 50-50 co-parenting. If you have any questions about that, reach out. We'll be glad to help you out.